trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. Cause Sweet Peas on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when Sweet Peas in the building, we be learning with pride. My eyes on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Rachel with the facts, pretty brown girl with the sass. Moreldia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate, take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet Pea breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you're out of line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made a goal. Take it to trial, from day to night and every wild mile. Sweet Peas nearly strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial, yeah, we live tonight. Take it to trial, yeah, we live tonight. Take it to trial.
Yay. What's up? What's up? What's up? Hey, everybody. Hey, everybody. I tell you, what a day, what a day, what a day. Oh, man. Man, oh, man. Hey, Marilda. What's up, Lexi? Lexi said there's some hood stuff going on. I'm jumping on in here. What you been up to, Lexi? Hey, SD. Good morning, Claire. Afternoon. I don't know what time it is, where nobody is at this point in time. But hello, hello, hello. Hey, boss. What's going on? Time. I'm thinking about Rick Ross when I'm hearing this song. You the boss, baby. He said, hey, you just been working. I know that fella. Well, guys, so I got a couple updates in regards to this trial. Y'all know they are doing jury selections. They are currently in jury selection as we speak. Just after 6 p.m. there. Okay. Also, it's evening time, so I should say good morning, good afternoon, good evening, depending on where you at. It might even be the next dang on day into Thursday. Shit, I don't know. But here we go. Yeah, so I found out today they are in jury selection, just so y'all are aware. Okay, so you on the West Coast, the best coast, boss. That's what time it is here in Arizona. West Coast, the best coast. Marilda said it's 7:04. She almost into Thursday. What y'all saying? What y'all saying? What y'all talking about? So I did find out today. Okay, jury selection has started in the Foolio. You know, the last 4 defendants that are going to be standing trial. It is a DP case. what I found out today is, y'all know, it's 4 different defendants, 4 different attorneys, and then we got the prosecutor's office. So what we can expect, from my understanding, it may take like 2 weeks to pick a jury, y'all. That's just to find out who's going to decide this case, because not only are we talking about 4 different defendants, we are also talking about a DP case. So they have to, everybody's going to be able to question all of the jurors, like each person. So there is that. So I did speak to somebody at the courthouse, and he is so nice. I ain't gonna just deliver his name, but he called me today and he was like, I will let you know when jury selection is done, so you can go ahead and set everything up. So I appreciate him. Shout out to him. He know who he is. I don't have to explain it, but I appreciate it. So he gonna text me when we ready to rock and roll. But in the meantime, before we get started with our verdict watch for our Hawaii trial, we did have some hearings that were done in this trial. So I did want to watch these hearings to kind of see what was determined before we actually go into the trial. Like I said, I will keep up on the documents to kind of see where we're at, but we'll just kind of deal with what we have right now on the table, so we can see in these hearings, because these make or break a case. What's being determined, what's coming in, what's not coming in, what the judge is going to allow, what she's not going to allow. And y'all know we are dealing with the same judge that did Alicia Andrews. So yeah, so there's that on that part. Now, a lot of people will say, like, why is the judge who did Alicia Andrews the same judge that's doing this case, considering that she got kicked off the Alicia Andrews case? Well, I guess because, they expect judges not to be biased, right? Even though she got kicked off for being biased, they expect them to be able to have a clear mind and all of that stuff. So there we go. So that's why she's still on the case. So we'll go through it. We'll go through the court documents, some court documents if we have time. And like I said, at 12 o'clock, we do have to get into our other case. I mean, I guess we don't have to rush over there, because I don't think the jury gonna come back until after lunch, but it is what it is. So hopefully sooner than later, we'll have a verdict in that case. Okay, let me get that set up. Okay, so here we go, guys. I am going to get us into the courtroom. Let me get this all set up for us. And then we'll look at this current hearing that we have here. I'm telling you, with thing 1 and thing 2. This is thing 2 right here on the screen, y'all, because I can't remember none of their names, but I definitely hope they get a damn haircut before this trial. If not, they can might as well they done sealed the deal with their hair, because they are guilty because of this hairstyle that they wearing. I want him to cut his hair. They have to cut their hair. This is scary to me. Just the hair right here is scary. So he got to cut his hair. This is thing 2. So if you ever hear me talk about thing 2, here we go. That's him. And I'll show y'all thing 1, because I don't know what else. I keep getting them mixed up. So I just call him thing 1 and thing 2. I don't know if he medicated. I don't know what he is. He probably is on some type of drugs. I don't know, because he looks stone-faced in the mug, and this is just his look the entire time. So they probably got him on something. You say he look well out of it. He probably is. Can't handle it. Like, now that he behind bars, they be thinking they everything and anything, and then they get behind bars and they got to deal with that real shit, and they can't handle it. You can't handle the truth. Yeah, that type shit. But it is what it is. He made his bed, now he about to lie in it. And then now he about to fight for his life. Like, this is a DP case, y'all. For unaliving Foolio. Like, and y'all know Foolio is the same person that will be clowning them, talking about them, all of these different things. Like, and at the end of the day, he gonna win if these boys get the DP. Like, this was so stupid. And I keep telling y'all people, if y'all in Florida, y'all better sit down because Florida is giving out the DP like nothing. Every redrawn place that we even almost cover, and they got DP on the table. So you can try it in Florida if you want to. Florida is tired of y'all messing up the Sunshine State. They said it's too sunny out here to be thugging. So if you want to be thugging and you want to be redrumming people, we gonna give you the DP. Here, eat this DP. That's what you can do. So I'm just letting y'all know that's what I'm saying. So y'all do all four of them for the DP. So they can do it if they want to. Now I'm telling y'all better stay out of Florida. Y'all better go to one of these states that don't have a DP. Go down to Florida, they're giving it to you. So if you don't want it, you better stop it. Yeah, thugging does not pay. You got that right, SD. And they are learning their lesson. I think the only person that was didn't have the DP on the table was Alicia. Alicia, like, it's too hot for that. Don't you agree, Lexi? Like, how you gonna be thugging and it's so hot? I can't understand, like, even down here, like, hot, it's too hot. And you know, in Florida, it is humid, it's so sticky. You gotta take a shower every 5 minutes. You do not have time to be out here thugging. Not to me, but apparently these people have time for it. And now that they got the time, you're gonna have to you did the crime, now you gotta pay. And yeah, now they gotta fight for their lives. And I do mean fight for their lives. All right, let's see what we have here first. The last hearing, like I said, this is the last hearing that they had, and then it's another little small one that they had. I think the other day that I'll show you guys, but this is it. And like I said, they're in jury selection right now. So here we go. All right, guys.
Okay, very good. The defendants are present. Defense counsel is present. The state is present. And I need to get my glasses because I can't see until I have my glasses. Okay, so I'll be right back.
Tell her get her glasses
in the office there.
I can't see.
Either on the desk or in my purse on the interior pocket.
Y'all know I showed y'all she was the same person that did Ronnie O'Neal's case. I think he stressed her out after having to deal with that man. Boy, oh boy, I wouldn't want to do none of these trials again. Did he get the DP?
Thanks. I set him down, and I'm like, yeah, I can't see. Okay. So I have reviewed the following motions. Isaiah Chance has a motion in limine, and the state filed a motion to compel disclosure of raw data generated during administration of tests for a number of the defendants. And then Rashad Murphy filed a defendant 6 motion in limine as to Robert Howard. Are there any other motions that we need to hear today other than those 3?
Judge, I believe Mr. Harmon filed yesterday a motion for order in limine having to do with the verdict of Alicia Andrews. Did you receive that?
I don't believe that I did.
It was filed yesterday.
I thought we discussed that already, but
we did briefly, Judge, and I think that's why Mr. Harmon filed the motion.
Okay. Yeah, and I indicated that it was certainly not relevant during guilt phase.
And so this has to do with penalty phase.
Okay. Well, I don't know. So, all right, I haven't reviewed it yet, so I'll take a chance and take a look at it. Take a second and look at it after we do these. Okay, y'all care which ones we start with?
I think Ms. Isberg was hopeful that we could do Mr. Howard's motion in limine last.
Okay, sure. All right, so why don't we start with the state's motion to compel disclosure of raw data generated during administration of tests. And I have a motion filed as to Rashad Murphy, Davion Murphy, and Isaiah Chance.
Very quickly, just for the record, Christopher Delauder is going to be sitting in. He is a certified second phase attorney. He wants to get some experience on first phase, so he will be sitting in with myself.
For the remainder of the trial or just today?
That's correct. As much as he can. Really
Sure. That's fine.
The court to be aware of that.
Yes, thank you. Good morning. Okay, so those are the three defendants. Did Mr. Gathright, do you have one as to Mr. Gathright or no?
No, Judge, these were, it's my understanding from Mr. Harmon, these were the only three defendants that had mental health experts in this area.
Okay, so Mr. Gonzalez, as to Rashad Murphy, do you object?
Judge, I think that would be.
Oh, I'm sorry, Mr. Hernandez, do you object?
What motion is this?
It's the state's motion to compel disclosure of raw data generated during administration of
No,
tests.
Your Honor. Obviously, that is done directly from one doctor to the other. We don't get involved in it, but I contact my doctor and it gets sent directly to the state's doctor.
Okay, and obviously, and I don't know, only you know, in the raw data, your expert may know, if there's anything in there where the defendant spoke about the facts of the case or defense strategy, then obviously that data does not have to be disclosed to the state.
I would have to check with the doctor, but based on the deposition that was taken once a week, I think that that's not going to be an issue because in response to one of the questions, my doctor indicated that the defendant had not discussed whether any issues regarding guilt or innocence. So I don't think that's an issue, but I would have to double check with the doctor.
Okay, well, just make sure that they know before the data is conveyed to the state that if there is anything in there that that can be redacted or withheld, but you just need to, essentially, what I would need the doctor or you to do is to make some type of privilege log, just so it's reflected that this is what we held back and this is why. And then if there is a finding of guilt as to first degree murder, and if we're going into a penalty phase, then potentially that material would have to be disclosed, but we can discuss that if we get there.
If once the state can provide me an email for the doctor, I will reach out to my doctor to have it sent with the court's instructions.
Okay.
That's fine, Judge.
Okay, very good. All right, so as to Mr. Sonardi, as to Davion Murphy, do you object to the motion?
Yes.
Or go ahead.
Yes, correct. To the state's motion you're referencing?
Yes.
Yes,
Okay, just you don't think any raw data should be at this point disclosed?
correct,
Based upon what?
correct.
No, based, what is your argument? What's it based upon?
Just adopt the other co-defendants' arguments as to that.
Okay. Okay, so I'm going to grant the motion with the same exceptions. Mr. Sonardi, you just need to confirm with your expert that they are to supply the raw data to you get the information regarding the state's expert. However, if during the interview of Mr. Davion Murphy, if he made any statements regarding the facts of this case or any defense strategy, then those statements or that data does not have to be transmitted, but you do have to create a privilege log if you're holding it back. Okay. All right, and finally, as to Mr. Isaiah Chance, Mr. Petratus.
We would object. I spoke with our doctor, and her concern was that the state's doctor is a psychiatrist, not a psychologist. We don't train in the test that she administered, specifically to Mr. Chance, based on that.
Okay, well, that sounds like a jury issue, potentially, cross-examination or direct examination issue. So I'm going to grant the motion. Again, Mr. Petratus, the same thing. If there is anything contained in the raw data regarding defendant statements as to the facts of this case or as to any defense strategy, that does not need to be conveyed to the state's expert, but you would need to create a privilege log. Okay? All right, very good. All right, so Mr. Chance's motion in limine, and state, do you object to this motion?
Yes, Your Honor, the state this morning filed a response with its motion limited. It was filed yesterday, provided courtesy copies via email to the court and provided physical copies to the defense attorneys as well as the courtesy email this morning. We included the argument from Mr. Petridis as well as the argument on behalf of Davion Murphy for the YouTube videos that were listed. Mr. Petridis.
Well, this is all I've got. This is all I've got. Mr. Chance filed a motion in limine and wishes to have excluded any allegation, mention, inference, or indication, whether through witness testimony, picture, video, or attorney statements to the jury of music video or stills from the video, quote, blood on my Pradas, close quote, by Isaiah Chance. Said video has no direct connection to the murder of Charles Jones and has imagery, firearms, dead body, etc., that would be unduly prejudicial without any probative values. That's what I'm referring to.
Yes, Your Honor.
Okay, so you're objecting to that.
Yes, Your Honor.
And what's the basis of the objection?
The evidence, there is items or are items of evidentiary value contained within that YouTube video presented at the state's evidence view. The state did decide to utilize screenshots in lieu of the video itself. Those screenshots depict the defendant only, not the dead bodies in his videos, and all of the violence from the videos. We actually limited the exhibit itself to several screenshots, well, many of which prove up elements that are required for the gang enhancement.
Okay. And what's your response to that, Mr. Petridis?
Just not withdrawing my previous discussion of the gang.
Right.
But if it's just photos of him with the, I assume the 23 chain, stuff like that.
Do you have the still shots here?
Yes, I presented the still shots videos at trial at the evidence view to defense.
Okay.
I have them electronically as well on my computer, Your Honor. I can pull them up if necessary.
I have the 3 photos, I believe. 2 of them just Mr. Chance with a 23 chain. There's no other imagery that we would object to. The other issue is, though, the name of the video is one of the pictures, and I would object to the name of the video.
Okay. What's your response to that?
The state, in admitting the evidence, is proving the authentication of the video and the source from which the video derives. So, identification of the defendant, number one, given that the subscriber information records linked to this defendant, the title that's used or the name that is used by the defendant is not his legal name. So it's more than just authenticating the video, but also identifying the defendant for purposes of this exhibit.
Okay, for record purposes, we probably need to identify exactly what it is we're talking about. Can you either display it so I can see it and Mr. Petridis can see it, or you can?
Yes, Your Honor.
Also, while you're doing that, we had a superseding indictment, correct?
Judge, that is correct. The only thing that has changed is count 2, which is the conspiracy count. We expanded the time frame of the conspiracy back to June 6th of 2024. That's the only change to the indictment.
Okay, Mr. Gonzalez, on behalf of Rashad Murphy, how does your client plead?
We would plead not guilty, Your Honor.
Okay, Mr. Sonardi, on behalf of Davion Murphy, how does your client plead?
Plead not guilty.
All right, Mr. Wise, on behalf of Mr. Gathright, how does your client plead?
Not guilty.
All right, and finally, Mr. Petridis, on behalf of Mr. Chance, how does your client plead? Okay, very good, thank you. All right, and while we're waiting on Ms. Ismer, let's just talk a little bit about jury selection, okay? So while I spoke with jury services and they're summoning enough people, they hope,
So just so y'all aware, a superseding indictment is when prosecutors go back and they update or they replace the original charges with the new version. So it's like 2.0 is what I would say. So that's why everybody is like pleading not guilty, because there is a superseding indictment. So they added additional co-defendants, clarify who did what in the shooting. They strengthened the conspiracy angle. So that's why they did a superseding indictment. And it does allege who planned it, who carried it out, who helped before, who helped afterwards. So it matters just because the prosecution, like, look, we got more information. So here we go with more things to provide to you. So now we want another indictment. How do you plead to these charges? And there we go. Everybody says no, not guilty, not guilty, not guilty. So there we go with that. Let's see what they talking about in regards to our jury pool.
To at least get 150 in here, okay, 150 people. Actually, let me back up. We're not doing jury selection in this courtroom. Okay, so we're doing it in courtroom 1. So we have just because I'm going to need to be able to utilize the lobby outside to seat people, and there's no lobby outside of this courtroom that would be large enough to accommodate 150 people. So we're going to do all of the jury selection in courtroom 1. We're going to try the case in here. All right. So I know we can get 150 in the audience on the benches. My bailiffs also determined that we could get an additional 25 in the jury box with some chairs in front. So conceivably, if 175 people show up, we can get 175 in courtroom 1. My inclination is if we have the space and we have the people, we should just bring them in. So that's my initial thought on that, is that it actually would be 175 people, assuming we get 175 Wednesday, Thursday, Friday. So then my question to you all is, as far as numbering them, my inclination is to do 1 through 150, like normal, like what I normally do in the audience and the benches. And then do 151 through 175 would be on the side where the jury box is. And remind me, Ron, Reggie, how many chairs do we have to put in the front?
In the jury box?
Yeah, outside the jury box.
7, 6, 6, 6.
Okay. So what I will do is I will have my JA come up with just a general seating chart, so you know the numbers of where the people are going to be. All right. And then starting the next day, then we would start with.
Oh my gosh, what the heck was that loud ass noise? Gee whiz. That was not me. That was definitely them in their courtroom feed. This was a bad time to pause it on thing too, because look, his eyes look like they about to roll in the back of his dang on head. We already thought he was medicated. He really looking something strange right now. They are bringing in 175 jurors. Wow. Wow. Y'all heard it. Wednesday, Thursday, and Friday. So let's go ahead and continue to listen.
176, put 150 out there, and then if we get the extra 25, again, put them on the side, and the same thing with Friday. All right, so I will do seating charts for you all with that anticipation, and you can at least use that. Okay.
Obviously, with the benefit involved in the length of the trial, I suspect a lot of individual work on it. How do you plan?
So this is what we do with regards to this first round. And I think we discussed this before, but you may not have been here with Mr. Hernandez. So how this is going to work is phase 1 is going to be questioning with the jurors about hardship and whether or not they can serve, and then pretrial publicity. So what I'll do is when we get the list of 175 names, all you all are to do is simply write down the name and the number. That's it. Don't start looking at slips. We're just get down the name and the number.
I will give my introductory speech that I do in all death penalty cases. Plus, I normally don't instruct them on the death penalty at this phase. However, in this case, I am going to give a preliminary instruction because, unlike my normal practice, I am going to break down the people that can serve into smaller groups for death penalty voir dire. And the initial instruction on those jurors normally takes a while because I know I have a long speech I have to give. The state normally gives a relatively long speech, and then the defendants can give whatever speech they would like to. And I don't want to have to repeat that every morning during voir dire of the penalty phase, which would be phase 2, because it just sucks up time. So I'm going to give my preliminary instruction on the death penalty. I will then allow the state to give a preliminary instruction. You all can give a preliminary statement if you wish. And then what I will do is I will then ask the jurors 2 separate questions. I'm going to ask them first to raise their hand if they're going to claim a hardship for while they cannot serve. And then I'm going to read a statement, and I need to get an agreed to factual basis from you all to read to the jury and ask them if they think they know anything about this case. I will probably, so for those individuals that raise their hand as to knowledge about the case, pre-trial publicity, I will do individual voir dire, and we'll do that first. We'll bring them in one at a time. For those that are claiming a hardship without pre-trial publicity, I will do those in groups. So I'll bring them in, probably have enough to seat in the first row of the audience, and then I will ask them the initial question as far as what their purported hardship is. And then I will allow each of you, if you wish, to do any follow-up questions. And then once all of those individuals have been questioned, then we will determine who can be excused. And at the outset, just so you know, I will excuse people for cause at mostly at lunchtime and at the end of the day, but only if everyone agrees. So if anyone objects, either the state or any of the defendants, to any of the prospective jurors being excused for cause at that juncture, I'm going to leave the person in the pool. So because you may want to rehabilitate them, I don't know. Okay. So the individuals who do not raise their hand at all, who don't know anything about the case and who are not claiming a hardship, they will be excused until Monday. And then they will come back to begin the first smaller group for death penalty questioning, which is phase 2. So my goal is to hopefully have smaller panels of 30 to 40 people just for death penalty voir dire the following week, which would be Monday through Friday. And then once that is finished, then the following week, Monday and Tuesday, will be general voir dire for those that remain. All right. So I am well aware of the number of peremptories, 40 total for defense, 40 for the state. So I'm hopeful that we will have, at least 150 come back for the final phase. We'll see. So this is just going to be a situation where as we go along, we will see how things are going. All right. So then if I get, let's say, more than 30 people who can come back the week 2, I'll push some to Tuesday. And then same thing, Thursday people will come back either Tuesday, Wednesday. Friday people that come back will come back Thursday or Friday. I won't know until I know what the numbers are, exactly what day they're going to come back. But just so you all know, it will be smaller panels, week 2, 30 to 40, just on death penalty. Okay. So Mr. Hernandez, is that a long-winded way of answering your question? Okay.
Judge, one question I have.
Sure.
The statement that the court's going to allow defense and state to make after your initial inquiries, what is the court anticipating with regard to that statement?
I'm assuming it's just pretty generic, just enough to trigger their memories. We had a statement in the Alicia Andrews case that you all may or may not agree to, but it's kind of just basic parameters, things like that this was a shooting that occurred up near USF on the date in question, and that it involved an allegation of potential gang involvement, and the victim was Charles Jones, known by his rapper name Foolio, something like that.
And that's the statement that's going to be given by the court.
Correct.
What about the statement that you're referring to that you would allow both the state and defendant?
That is the statement. No. The statement
You're
that
talking about something that we are allowed to get up and do with that.
Yeah, no. No. There's two separate, I guess, statements. So the first one is the one I would make in anticipation of my question about pretrial publicity. Okay. The next would be with regards to the death penalty information. And again, just from experience, Mr. Harmon has a script that he uses, and I don't believe in any of the cases I've done, defense actually said anything in addition, really. So you don't have to. I'm just letting you know that if you would like to stand up and just give because I'm allowing the state the chance to do it, to give a general instruction or information about death penalty qualification.
Fine, Judge. I need some clarity.
Yeah, it's just, I don't think any defense attorney has ever done it, and you don't have to. I'm just giving you the opportunity if you so wish.
Understood.
Okay, but normally between myself and Mr. Harmon, we cover pretty much everything. So, okay. And I'm also considering, and you guys tell me if you think it's a good idea or a bad idea. Once we get our jury picked, so this would not include next week, I'm considering giving the jury Fridays off. Mr. Sonardi gave me the thumbs up. You guys. I'm hoping that will be some sweetener to encourage people to want to volunteer to serve, since they know they at least will get Fridays off to handle their personal affairs or do what they need to do. But you all tell me.
Certainly always a good situation with regard to getting people to want to serve, and certainly allowing lawyers to do what they do. I don't know if the state has any indication. We haven't gotten a final witness list yet, which of course no one's obligated to do.
Right.
But to the extent, would the state have any indication as to what they think their case in chief, short of a catastrophe, might take? I'm just more looking about, quite frankly, Judge, my calendar beyond
Sure.
the 15th. And there are some challenges there. And I need to know whether the state has any idea as to what they might.
So let me ask you this. So let's just talk about this a little bit. So hopefully, if everything goes smoothly, jury selection will be concluded by Tuesday, April 21st. Okay, that's my goal. I will be working very hard towards that goal. That means we do opening statements on the 22nd and begin with the presentation of the evidence, the 22nd and the 23rd. I can tell you right now, we will not have court on the 24th of April. So then the guilt phase portion would begin again April 27th. And we'd go through that week. And then depending upon things and depending upon if there's a finding of guilt as to first-degree murder, penalty phase would begin May 4th or thereabouts and last most of that week.
Does that comport potentially with what the state would anticipate from a case in chief standpoint? And again, I'm asking a question that they may not have the answer to, Judge. I'm just inquiring.
I think that in general terms it does. I know that this trial will be somewhat longer because there's more attorneys, but
Sure.
I think that that's a good general guideline.
So I'm trying to remember how many days did it take us in the Andrews case? 7? Well, remember we picked a jury though.
Correct. Yes.
starting, I can't remember, do we start Wednesday or Monday? I think it was Monday. Did we start Monday? Yeah, I don't
I'll have to go back and
know
look.
either. Let me look. I don't know. What month even was that? Who
I
could
know
even?
It came in on October, on Halloween.
Okay, let me look.
5 years ago now?
Yeah, it feels like it. Yes, it was. Yes, it was. Okay, well, I don't have that with me. So anyway,
That gives me a much better indication, Judge, without nailing anybody down, that actually answers my inquiry. truthfully.
yeah, it took us a couple days to pick the jury in that case. It took, 2 to 3 days to get the jury picked. So it took us, I'm going to say, about 7 work days to get it tried. So maybe 8 or 9, just because we have more lawyers, but I would say 8 or 9 for guilt phase portion of the trial.
There may be a few more witnesses in this case.
Okay.
And probably a little more extensive testimony from those witnesses, because I think there were some limitations
Sure.
in Andrew's case that probably don't exist here.
Sure. Okay. So, yes.
I guess along those lines, I think it's safe to say that I should, if there is a need for a penalty phase, I shouldn't have any witnesses ready in April. It should be May.
Yeah, it'd be May. I would say May 4th at the earliest. May 4th at the earliest. And I'm going to ask Mr. Hernandez, what's your absolute need to be done by date? Mr. Gonzalez, what's your absolute, and Mr. Hernandez, what's your absolute need to be done by date?
Judge, preferably the 18th or 19th of May. I don't know whether any of those days fall on the weekend, but.
Yeah, we'll be done by then. Okay. Mr. Sonardi, what about you? Any?
Fine.
Okay. Mr. Wise?
Your Honor, my only, sounds like, I'm on the same boat as Mr. Gonzalez. I had everything blocked off for May 15th, so starting May 18th, I have.
Yeah, we'll be done by then. We'll be done by May 15th. Okay, we will. And Ms. Petratus? Okay, yeah, we will. So, okay. Very good. So now that we've discussed the calendar, so at this point, I won't commit to the jury taking Fridays off. I will tell them Friday, April 24th for sure. And that if we're making good progress and it looks like I can give them a Friday off, then I will. But at this point, I'm going to be conservative because it's more important that we, the trial gets completed in a timely fashion. So, okay. Okay, Ms. Ismer. Yep.
Yeah, the signature, I have to tell these guys that that's what it looks like. And Connie made that
Yeah.
sheet in the back. Want me to just make a copy and give it to
That'd be
them?
great.
Okay.
Excellent. Okay, so this would be, the state is displaying, this is a still shot, blood on my Pradas, and that is Goudaze, which I believe is a name that Mr. Chance goes by, correct?
Yes, Your Honor.
Okay, and did y'all hear how she tried to pronounce his name? Goudaze. I think it's Goudaze, but it's funny trying to hear her pronounce that stuff. She said Goudaze. I think it's Goudaze, but it's funny. And when was this distributed or?
I'd have to look back at the original motion for the date.
Okay, or posted September 2023.
I
Okay.
think the 8th of 2023.
Okay. So this is the one you object to.
This specific picture.
This specific
And
picture.
I'll say, we're not going to be objecting to Detective Meter or someone who knows him saying that that is Mr. Chance. And we're not going to be objecting that is the name that Top Kaze that he uses. But I don't, and we're not going to be objecting to this based on your ruling. The other two pictures, which is him wearing a 23 chain.
Okay.
Shown in this picture. So I'm not gonna object to this and then try to jam up the state later, but it's this specific picture. I don't think it's necessary to show blood on my product.
Well, yeah, so what if they just redacted blood on my Pradas?
Well, I would say that what he's doing in that picture could be interpreted negatively, whereas they're just trying to show him wearing the 23 chain in a music video. I don't want to say stipulate, but I'm not going to object to suggesting this was a video he made on September 8, 2023. That is Mr. Chance, and he's wearing, it can be very obvious in the other two pictures, a chain, number 23 on it.
Yeah, well, it looks like, just for the record, it looks like he's maybe mimicking shooting a gun or shotgun or something. That's what he appears to be doing. So why do you need the title "Blood on My Pradas"?
All of the other exhibits from YouTube include the title and the account name for the individual who posted them. So to redact only this screenshot or only this defendant's music video, which indicates obviously still images for at least this exhibit of the defendant wearing his gang chains or talking about offenses or crimes that are linked back to the gang that he's affiliated with, I think it causes a discrepancy in what evidence is being presented. The defendant would, in this instance, be the only person whose music video title isn't also displayed alongside of all of the other videos which are establishing his gang enhancement.
All right, let me see the other still shots, just to make sure for the record.
This is still shot 1. And still shot number 2. Both have been redacted to remove the guns or body parts that were depicted.
Okay. And this is going towards the gang enhancement, correct?
That's correct, Your Honor.
Okay.
We'll seek testimony as to the lyrics because in playing the video, obviously, we knew the defense would have an objection to all of the content, which is why we've redacted to these specific images.
Okay, very good. All right. So based upon the state stipulation to limit this exhibit to the 3 screenshots, I'm going to overrule or deny the motion in limine, followed by Isaiah Chance. I find that the evidence the state seeks to admit that its probative value outweighs any prejudicial effect. Okay, and next would be the motions I have a copy of. Defendant Rashad Murphy's motion limine as to Robert Howard.
Judge, this is an all-encompassing motion, as the court can see, regarding several different areas. And it is buttressed on the statement provided and ultimately made confidential, made by Mr. Howard in August of 2025, as well as his deposition taken on February 4th, 2026. It seeks to limit, based on what I believe is hearsay, improper speculation by Mr. Howard, and pre-conspiratorial statements that are attributed to other defendants. Certainly understanding the court's ruling with regard to severance, I still have concerns about evidence that may in fact be admissible against one defendant and not admissible against others. As it relates to the hearsay statements, Your Honor, any statements that Mr. Howard alleges Mr. Murphy made as it relates to threats to him or his family are statements that he heard from other individuals. And that's based on his testimony at both his statement and his deposition. He talks about things allegedly stated by Mr. Murphy that were told to him by others, and goes on to suggest that in his alleged conversations with Mr. Murphy on multiple occasions, he didn't consider those conversations either threatening nor friendly. So certainly buttressing that feeling and that speculation and that statement being what he's been told by others.
Okay, so maybe it'd be helpful if we just went through these statements. You've broken out the different statements per category, right?
Yes, Judge.
So let's just start with the hearsay statements, beginning at page 2 of your motion. Specifically, you allege that Mr. Howard testified that he heard from other individuals that Murphy had made threats.
That's correct.
Okay. State, were you intending to elicit that from any Mr. Howard?
Is this as to paragraph number 5, Your Honor?
It is.
No objection as to statements you heard from other individuals, only statements that Mr. Howard heard directly from Rashad Murphy would be suffered.
Okay, so as to paragraph 5, it's granted. And then paragraph 6, Mr. Howard further clarified that he spoke with Rashad Murphy on multiple occasions. Oh, so that's
just
different.
providing
Yeah.
context.
Okay. And then the next would be paragraph 7. Mr. Howard testified, subparagraph A, that he communicated with Isaiah Chance, who told him that Murphy was hot about Adam's murder. State, are you seeking to elicit this from Mr. Howard?
Yes, Your Honor. Any statements that were made by any unaffiliated party with the case, the victim, as listed in this motion, the state's not seeking to introduce. But statements made by the defendant or co-defendants in this case, the state is seeking to introduce. Not as statements of hearsay, they're not being offered for their truth, but to establish intent and premeditation and motive in this case.
Okay.
Judge, it also goes to admissibility statements as it relates to Mr. Murphy. And the argument would be it's not a co-conspirator statement based on when it is said. And in fact, I think the state would have to establish when that statement was made to determine whether or not it was in the course or in furtherance of any conspiracy. And I don't think they can do that.
So state what your argument is as far as why this is admissible if the statement was made not during the timeframes of the purported conspiracy.
Because Mr. Gonzalez's argument reverts back to a co-conspirator admission, which is a hearsay exception. The state's position is that it's not being offered as hearsay. So understanding the limitations of a co-conspirator hearsay statement, we're not offering it as a statement of hearsay in the case. It is strictly being offered as proof of other elements, so knowledge, intent, premeditation. The state has filed in its initial response to the court and had previously provided to the court the case law on this before Mr. Gonzalez's motion. So the March 5th response gave the case law for all of the reasons that the state sought to introduce each of these statements, Your Honor, and we would rely on that case law.
Okay, I'll come back.
Mr. Howard can't testify to what Mr. Chance told him about Mr. Murphy. And I don't think it's admissible based on any theory of motive.
Isn't it double hearsay?
The statements that Mr. Murphy was hot are statements that are made from Mr. Chance to Robert Howard telephonically. Is that what are these the ones you're referring to, Mr. Gonzalez?
Yes.
Okay. And so the state's not off, again, the state would just reserve the same exact basis as for why the evidence is being offered. It's not being offered for its truth. So continuing to indicate that because it's an out-of-court statement, it invokes co-conspirator hearsay when the basis for why the state is offering the item of evidence is strictly the defendant's knowledge of what was to occur, the premeditation of the act of what is to occur, because the context of that conversation is in telling the person listening, which is the witness, Mr. Howard, to be careful, essentially, when he goes to Tampa. These things are in context being offered for a different purpose than a hearsay or co-conspirator statement or admission.
Let me think about it. Okay, the next one, subparagraph B of 7, Howard testified that Charles Jones told him to watch out for Murphy because of Murphy's purported threats.
No objection from the state.
Okay, that one's granted. Subsection C of paragraph 7, Howard testified that he heard rumors that Murphy was riding past the prison that Howard was at.
No objection from the state.
Okay, granted as to 7C. Okay.
So I think that takes care of all of the statements identified in your subsection under hearsay. Is that correct?
That's correct.
Okay, moving on to opinions, speculation, beginning at page 3, paragraph 13. Howard testified about a Bill Belichick and Tom Brady social media post, which he attributed to Isaiah Chance following the murder. Howard speculated that the post referred to Charles Jones because Brady is the GOAT of football and Charles Jones is the GOAT of rap music. State.
The witness's impression or his specific observations, I don't expect he'll be testifying about what Isaiah Chance meant, but only about what he understood the post to be.
Judge, I think that's inadmissible. It's asking Mr. Howard to speculate, give his opinion as to what he thinks something might mean.
Well, what was the
Not an
actual,
expert.
yeah, what was the actual, what was it that was posted and what was the content of the post?
A photograph, so it was not a part of our hearsay argument that we previously provided to the court of Bill Belichick, a coach of the New England Patriots team. There were consistent photographs of either Tom Brady or Bill Belichick posted by the defendants.
So Isaiah Chance posts photos of Bill Belichick and Tom Brady.
Yes.
Is there any words attached to the post or just the post?
No words on the Bill Belichick photo. I think hands up. I'm not sure how to describe the emoji, but an emoji on the photograph, but not words associated to that post. There were other Bill Belichick posts in the co-defendant's devices, so I have to pull them up to check for language. But to my knowledge, having discussed that with the defense attorneys, I didn't believe there was any other language that was on those photos.
And this was post murder of Charles Jones?
Correct. These were posted, some within minutes and some within the first couple of hours after the homicide.
Just for context too, Judge, some people may think Tom Brady is the GOAT of football. That's your opinion. Some people may think that Charles Jones is the GOAT of rappers, and that's somebody's opinion. And I think that that needs to be considered in its totality along with the other arguments.
Yeah, I'm just trying to figure. And so what's it relevant to?
I believe if I recall correctly, the specific testimony that was provided by that witness in trial 1 was that while he was on scene of the homicide within minutes, he logged onto social media, saw that post, and immediately knew that the poster had done it. Like that was the testimony that was provided. There was nothing specific as to the defendant's state of mind or what the intention behind posting the photo was. It was whatever the witness had observed on scene in that moment as he was checking social media and before they were able to notify the family or the media having arrived. That was the testimony that was received, and that's what we anticipate will be the same in this trial.
Okay. So within, how quickly did the post happen after the homicide occurred?
I'd have to check my timeline, Judge, because there are several across all of the devices that we have received. Isaiah Chance's post was on June 23rd at 6:13 a.m.
So is that the morning of the homicide?
Yes, Your Honor.
Before?
No, this is just after the homicide. So the homicide occurs about 5 a.m.
On June 23rd. So this is right after.
This was the
Okay. 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 So I'm going to deny the motion in limine as to the social media post. However, grant it as to any speculation on the part of Mr. Howard as to what Mr. Chance meant.
Judge, although I can't be positive, I looked at Mr. Petraeus' screenshot, and it looks like the post was made on 6:13 a.m.
Mhm.
And I think the murder occurred at 4:37 or 4:38, so it's a couple hours,
Yeah.
hour and a half, 2 hours, somewhere in that neighborhood.
Right. So I've denied paragraph 13 as to the post itself, but granted it as to any interpretation by Mr. Howard as to what Mr. Chance meant by it. Okay, next up, paragraph 14. Mr. Howard testified that Rashad Murphy texted him after the murder stating, "I forgive you."
And Judge, what we're talking about is not a text that the jury would be viewing. It would be Mr. Howard's testimony that Mr. Murphy texted him and said, "I forgive you," and then speculating that that is a result of Mr. Howard having been convicted of the murder of Joe Rod Adams in 2018.
Okay, State, are you going to seek to admit this?
We are seeking to admit it, Your Honor, for the same basis, the motive and intent behind the defendant having committed this crime. The testimony from Mr. Howard is that that message comes in within either the same day or the next day. I believe it's the testimony at depo at trial that he receives from the defendant.
He doesn't know when he got it, really, at the end of the day. Although he does limit it to within a day.
Okay, I'm going to deny as to paragraph 14, but granted as to any speculation on the part of Mr. Howard. Okay, paragraph 15, Mr. Howard further testified that, is that Rashad Murphy?
Yes.
Okay, spoke with him after the murder and that the two discussed their respective whereabouts. Mr. Howard testified that Rashad Murphy stated he was in front of Julio's car. Okay.
Yes, Judge. Mr. Howard speculated that what Mr. Murphy meant is that he was present at the shooting. But actually, Howard admitted that Murphy never stated he was present at the scene, nor that he participated in the murder. But the context of what he was alleged to have said was he was in front of Julio's car. He previously testified during his statement that in talking about the same discussion that Mr. Murphy alleged he was present at the Truth nightclub, not at the scene of the murder. And so obviously the inconsistencies are something that can be
Sussed out in cross-examination, yes.
But as it relates to him testifying that Mr. Murphy was in front of Julio's car and then testifying that what Mr. Murphy meant was that he was at the murder should be limited.
My only concern with this one is it gets a little bit convoluted. It is a part of the conversation that Mr. Howard is indicating that he's having with the defendant, whereas the defendant is completely describing the scene. You had your head on a swivel. You were looking here and there at each of the locations. And so certainly the state is seeking to admit it as identification, but I think this one, if the court is inclined as it relates to the speculation, maybe one that we ask if the court would allow that we wait until we get to that point in the presentation of the evidence. I don't know how we can slice that up, if that makes sense, based on the context of the full statement that he gave for that.
I just don't want during the course of direct testimony for Mr. Howard
To draw an opinion.
to speculate that what Mr. Murphy's talking about is he was in front of the car during the course of that murder.
Okay. So again, I'll deny paragraph 14. It's admissible. But again, Mr. Howard cannot draw opinions. He can only testify as to what was said. And then that's why we have closing arguments, and you guys can argue the meaning.
Did you say 14 and 15?
I'm at 15, yeah. All right, paragraph 16. Howard also testified that Rashad Murphy later told him, "It is all good. We good now." State, are you intending to introduce that statement into evidence?
Yes, Your Honor, but no objection as to limiting without speculation on the part of the witness.
Okay, very much. Very good. Then the paragraph 16 will be denied. But again, no speculation or opinion as to what Mr. Rashad Murphy meant. Okay, paragraph 17, Howard opined that social media posts referencing Don Julio were intended to disrespect toward Jones because Julio appears in Jones' Instagram handle. State, were you intending to solicit that opinion from Mr. Howard?
Not as it relates to disrespect, as it relates to Don Foolio or Foolio. If he has specific knowledge in this case about the fact that Foolio and Don Julio are linked because of his relationship to the case, I would ask that that be admissible.
And Judge, I guess, just for clarification, Mr. Howard's not going to be testifying to his opinion that it was done in a manner of disrespect.
Right. He's just going to say that
I saw bottles of Don Julio.
And to me, and based upon my knowledge and experience or whatever it may be, that is a reference to Charles Jones. Right?
Understood.
Okay. So it's denied with that understanding. Again, as to paragraph 17, Mr. Howard can testify as to the facts or what he knows, but he can't speculate on the intention of the poster. Okay.
It's the end, Judge, of those that.
Okay.
category.
Moving on to co-defendant statements.
And again, I'm going to preface before the state goes in, the court goes any further. Again, understanding the court has ruled
Right.
as it relates to severance. I just want the record to be very clear.
Yes, you're
Still
not.
have concerns.
Yeah, you're not waiving any objections that you've previously made. Okay. Let's see. Paragraph 25, Robert Howard stated that he had multiple conversations with Isaiah Chance in which Chance expressed his dislike for Charles Jones. He emphasized that Chance and Jones engaged in multiple social media arguments in which they disrespected one another. Are you going to be attempting to admit this evidence via Mr. Howard?
Yes, Your Honor, all of it will come in through the experts, except for one interaction which occurred between Chance and Charles Jones that Mr. Howard was the primary witness to. Otherwise, law enforcement witnessed the exchanges.
And certainly my argument has to be, notwithstanding other motions and other rulings, is that Mr. Howard not testify to that. It's coming in through a gang expert.
Right.
And as it relates to his direct interaction in seeing something occur, then of course I don't have a legal objection to that.
Okay. So it's a paragraph 25. It's sort of a general argument. I'm going to deny the motion in limine as paragraph 25. However, you reserve the right to make contemporaneous objections at the time of trial. So if something's coming in through the gang expert, then at that time, if you want to raise an objection, you can, but generally speaking, it's denied. Okay, and then there's a more specific statement at paragraph 26. According to Robert Howard, Isaiah Chance allegedly stated that Charles Jones was going to die. Do you seek to admit this through Mr. Howard?
We seek to admit the conversations that occurred within the time frame of the conspiracy that's listed as it relates to these conversations, but not from before that. The motion, though, is not clear because there were conversations which occurred outside of that time frame discussing the same type of comments or threatening remarks. Mr. Howard and Mr. Chance had some type of relationship which was jovial enough for them to speak often about this issue, but there are specific exchanges which occur which indicates that there are threats on the victim's life and for Mr. Howard to kind of avoid that danger when they come to Tampa. We know that's within the time frame, regardless of whatever testimony Mr. Howard was able to give in his deposition about the specific dates, because they reference the posts that Mr. Jones made to social media of the flyers for the events that were occurring in Tampa, and that occurred on June 14th of 2024.
Judge, I would only point out that certainly we have to rely on Mr. Howard's testimony as to when he heard these things. We have no other way.
I know.
And to the extent that he testifies under oath that he believed that it occurred at the end of 2023 or beginning of 2024, it would have been long before any conspiratorial time frame. And again, you know, as it relates to Mr. Chance, that argument can be had in another way. So generally, it occurring within late 2023 or early 2024 is a problem. And again, I would reiterate, as it relates to evidence that the jury's going to hear that they can consider against Mr. Murphy, it's a problem.
Okay. So there's two separate things going on here. So let's first discuss, if I'm hearing you correctly state, you're only intending to seek these conversations between Mr. Chance and Mr. Howard during the time frame of the conspiracy, correct?
Correct. The content of the conversations during that time frame.
Okay.
Otherwise, it is just generally the relationship between the two. Did you speak on the phone previously?
Right.
What was your relationship, but not the content?
Not the, okay. So with that understanding, that's what the state is saying. So it would appear then as to paragraph 26 and 27, because Mr. Gonzalez is alleging that Mr. Howard stated that this specific comment that Charles Jones was going to die occurred sometime at the end of 2023 or the beginning of 2024, which would be outside of your conspiracy timeframes, correct?
Agreed, Your Honor.
Okay, so as to specifically paragraph 26, that will be granted. Paragraph 28, Howard further testified that the ongoing dispute between Charles Jones and Isaiah Chance had escalated to the point that if they would have seen each other, they probably would have wanted to do something to each other. That appears to be Mr. Howard speculating. Are you going to seek to introduce that?
No, Your Honor.
Okay, so granted as to paragraph 28 is that statement. Yep. Well, 27 is not, it's just a historical fact. Okay.
The finding though, Your Honor, if I may, as to 27 and 28, they really should be together because the other remarks about Mr. Jones dying do occur within our conspiracy time period. So I don't want the record to be unclear. There are several remarks made within our conspiracy.
Right. So, okay. So as to 27, it's granted as to anything outside of the timeframes of the conspiracy, denied as to any statements made during the time frame of the conspiracy.
And certainly, Judge, subject to later potential objections, I would certainly having no reason to dispute what Ms. Isber saying. The state's going to have to, in order to admit those statements, lay a foundation as to when they occurred and whether they occurred within the conspiratorial time frame. Anything that Mr. Howard can't tell us when it happened, if that turns out to be the case, certainly I think should be excluded.
Okay. Yeah. So again, subject to contemporaneous objections at the time. But the appropriate foundation needs to be laid. Okay. Paragraph 29. According to Mr. Howard, Davion Murphy confronted him regarding Howard's involvement in Adam's murder and stated, "Bro, I'm going to catch up with you. I'm going to deal with you." This allegedly occurred at least 6 years prior to the conspiracy. State, are you seeking to admit this?
We are seeking to admit it, Your Honor, for identification purposes and for motive evidence. These statements were made specifically as a part of this quote as well, following Mr. Murphy's mention that Spaz, or the person that Mr. Howard was incarcerated for killing at the time, was his relative. And so he's shouting that at Mr. Howard at the time. Mr. Howard also being present with the victim in that parking lot on this evening would be a basis as to why we're seeking to introduce this.
Okay.
It occurred allegedly 6 years prior to Mr. Jones' murder. Number one, again, just so we're clear, there is problem number one, its admission of a statement 6 years earlier and how it might affect the jury as it relates to Rashad Murphy, since we are not severed, number one. And number two, it again falls, based on the prior arguments, far outside of the conspiratorial timeframe.
All right, let me think about that one. Reserve ruling. Okay. 30 is just a statement of law, paragraph 30.
One more thing, Judge.
Sure.
Also, as it relates to the fact that there are two Murphys here, and these Murphys are cousins.
Right.
I think there's a even more complex and complicated issue in allowing that statement to come in and how the jury may perceive it, and its prejudicial effect outweighing any probative value.
Okay. Thank you. I reserve ruling. 30, paragraph 31, Howard attributes several statements to co-defendant
Can we
Isaiah
talk about,
Chance.
Judge?
We've already discussed it. Okay, same ruling. 32 is just a legal
Context,
argument. Okay. I think that takes care of
It
your
does,
motion. Okay, so I'm going to think about
7A.
7A and then paragraph 29. Okay, I'll let you guys know.
Thank you, Your Honor.
Sure. And again, when we talk about the severance issue, again, just to clarify, we don't have a Bruton problem here. And then the only issue would be if there's evidence that would, quote, improperly influence, close quote, the jury, with evidence that would be admissible against one or more co-defendant and not all of them, which is kind of an amorphous standard. So it's kind of beauty in the eye of the beholder. So that would be the determination, whether that evidence would rise to the level of improperly influencing the jury.
And Judge, it goes without saying that the state would not be opposed to a limiting instruction from this court, specifically with instructions to the jury as to which defendant the evidence applies to at the time when we introduce those portions.
Sure, I understand. And it is a different, I did find really an abundance of caution, the two statements or the two text messages that the state agreed not to introduce were I think it was 2023, a set of text message exchanges between Isaiah Chance and Alicia Andrews. While those, in my opinion, are admissible as to Miss Andrews and Mr. Chance, it does predate the conspiracy. So in abundance of caution, those should not come in. The state agreed. The other one was, I guess, the celebratory comment made by Mr. I think Davion Murphy that was sent to Sean.
Judge, I don't believe we know which Murphy
Right.
specifically sent it, but it's
Okay.
signed Murphy.
Right. So for those reasons, and including the fact it was post-conspiracy and an abundance of caution, I didn't think it should come in as at a joint trial, and the state agreed. These statements that are made by the defendants during the conspiracy timeframe in particular are distinguishable from those that I thought should be excluded in an abundance of caution. As I'm trying to not tiptoe close to, quote, improperly influencing, close quote, the jury, as that phrase has been utilized in specifically second DCA precedent.
Judge, and just so the record is clear, notwithstanding the court's ruling, as it relates to the celebratory messages that are not coming in, there was testimony from Detective Ramos that, in fact, the witnesses he spoke to indicated that they didn't know Rashad Murphy. It was Davion Murphy that they were aware of, and that that's who they believe the text messages were sent by.
Right. So we had two issues with those messages. One, it was post-conspiracy, and two, the foundation of who actually sent it, which of the Murphys, is less than crystal clear. Right. Okay. Okay. So, and then the other motion was with regards to the Andrews verdict during penalty phase.
Yes, Mr. Harmon filed that, I believe yesterday afternoon. He is out today, but I said that I could cover it. Do you want to handle that now, or I don't know if you received it or not?
If I received it, I haven't seen a copy yet. So do you have a copy I can look at? Okay, thank you.
And Judge, we did briefly touch upon it. I believe that Mr. Petratus had filed a judicial notice of the verdict of Alicia Andrews, and we had spoken, and I think that you had previously said that obviously would not come in during the guilt phase, that it did not have a relevance. I think that Mr. Petratus had made some indication that he thought it might be relevant for penalty phase. And I think that is Mr. Harmon's objection. He filed a formal motion in limine objecting to that, as it would be improper and have no bearing or relevance to the jury's decision with regards to mitigation. It's improper character. There's no reason or way to tell this jury why the jury in Alicia Andrews made the decision that it did. There could be numerous, a myriad of reasons, including mercy, jury nullification. We don't know why they made the decision that they did. So what happens in one defendant's trial, verdict, or sentence doesn't have a bearing, or should not have a bearing in the current defendant's penalty phase. And so that was the basis of his motion.
Well, and it looks like there may be precedent, United States Supreme Court opinion, Lockett, right?
Yes, there was some case law that he filed as well.
Okay.
In support of his position.
Okay, so I tell you what, I'm going to take it under advisement. Let me take a look at this Lockett case, and then Mr. Petratus, do you have any additional, or does anyone have any additional case law, or do they want a chance to submit it?
I don't have any additional case law right now.
Okay, so I tell you what, I'm going to take it under advisement. I'm going to look at Lockett.
Sure, could we have a chance?
Yep. How much time do you need?
Briefly address something on that?
Sure.
I just looked up the motion this morning, but I think we're just dealing with sentence, not involvement, correct? Because
Correct.
I think that Alicia Andrews' involvement in a penalty phase can be compared to another particular defendant's involvement. But I'm trying to make sure that the state's motion is only dealing with sentence, not Alicia Andrews' actual involvement in this case.
Well, it says specifically in the motion, the subject matter in question is any argument comparing or regarding the verdict rendered by the jury to the Alicia Andrews case to the defendants, or otherwise arguing that fact as mitigation.
The point I'm making is that I think that her involvement, any defendant's involvement, which can be a problem when you have multiple defendants, but the involvement of one defendant versus another can be relevant for a penalty phase.
Okay.
Not verdict, as in the Andrews case maybe, or the sentence, but certainly one person can be more culpable than the other. And again, the problem is suggesting that maybe one defendant should get life and another defendant should get death.
Okay, so I'm going to give you guys a chance to research the issue and submit case law. Okay, so how much time do you need?
Yeah, at least a week.
Sure. Okay, so I tell you what, I will give you guys until Friday, April 10th to submit any case law to me on this topic.
Okay. Any other motions we need to discuss?
Your Honor, as a part of the state's response from this morning, the court had previously asked the parties to submit to the state any additional YouTube videos they intended to use or additional items of evidence that the court needed to consider. So the state did also address those things. I can tell the court that I've reviewed the videos that were provided, and the state does have some objections to those videos. I know Mr. Chance, on behalf of Mr. Chance, that there were 4 videos provided, and on behalf of Mr. Murphy, there were 4 videos provided.
Davion Murphy.
Davion Murphy. I will defer to the court as to how we address those, or if the court just wants to hear the state's objections as to those.
But do you have them identified?
Yes, and with a link in the event that the court or the other parties wish to see them as well in the motion.
But you haven't filed a motion in limine.
I have filed a motion, yes.
You have?
Yes, Your Honor.
Okay.
I filed it this morning because we received the defense to his motion in limine on their yesterday.
Okay. Well, can I take a look at your motion?
May I approach? Your Honor?
Sure.
So I kind of just emailed the judge. and he checked this with you.
Okay. Okay, all right, so according to this motion, state wishes to keep out, as to Isaiah Chance, a video titled List of Dead Ops that was posted on YouTube. A block party invasion went to Young and Ace block. It's a YouTube video. 3, God Don't Know by Julio Foolio. And number 4, Demigod by Julio Foolio. So are any of the defendants seeking to actually introduce these, and why?
These would be, these were sent somewhat in abundance of caution, but these would be rebuttal, depending on what is testified to by some of the state's experts, the gang experts.
I see.
And it would, they would be authenticated through that expert, if at all. It may not be necessary depending on direct cross-examination. And possibly only if it needs some still shots from some of these videos.
All right, so you're not intending to utilize these, and in your case in chief, seek to admit them in your case in chief. It would just be potentially as impeachment or rebuttal as to the testimony of the gang expert?
Correct, Your Honor, for a variety of reasons, based on gang certification and issues with Mr. Jones.
Okay, so then as to these 4 identified videos, I'm going to grant the motion without prejudice to revisit. If you think that you actually need to introduce them, we just need to talk about it before you do it.
Yes, Your Honor.
Okay? But generally speaking, the videos are not to be referenced or discussed in front of the jury until I've given permission for any party to do so. And then as to Davion Murphy, the videos listed are When I See You by Julio Foolio. Again, the List of Dead Ops. YouTube video Certified Killer by Julio Foolio and God Don't Know by Julio Foolio. And why is Mr. Murphy going to seek to introduce these, or what are you going to do with these?
Would be the same position as Mr. Chance becomes.
If you think they become relevant, then you would seek to introduce
That's
them.
correct. That's correct. Just to,
But you're not going to be submitting them as you don't anticipate at this point as part of your case in chief.
correct.
Okay. So that'll be the same ruling. Generally speaking, these videos 1 through 4, as to Davion Murphy, the state's motion is granted, however, without prejudice to revisit. And during trial and defense, you just need to confirm with me ahead of time before you start showing them or discussing them in front of the jury.
That's fine.
Okay, very good. Then we've got unrelated officer conduct,
counsel for Davian Murphy has filed a notice of intent to rely and listed a witness and records from the Jacksonville Sheriff's Office to include the personnel history of Detective Craig Griffin and Trey McCullough. Are you going to actually seek to utilize these records as impeachment?
Yes, Your Honor. I believe that's Ms. May's motion.
She filed a motion as to these?
Yeah, I thought that was what was correct.
Well, I don't have that motion in front of me. So did Ms. Tomei, did Davion Murphy file a motion in limine specifically to include this information?
She did not. She sent us an email with a notice of her intent to rely on the information, and she did file an amended discovery list with instructions that she would seek to introduce or admit the following videos and evidence, and then listed the witness as well.
Okay. So, Mr. Sonardi, is Ms. Tomei, is she handling this argument, this issue?
I said I was not aware that Ms. May was not going to be here. I'm really not in a position to argue that motion.
No, I understand. I honestly would like to see what we're talking about here, as far as what the actual evidence is. So,
We're not filing, Your Honor, but I do have 2 copies of the investigation history. I do not have copies of the civil lawsuits that were filed against the Jacksonville Sheriff's Office for the court because they were pretty lengthy. But I can provide these copies.
But I don't think that was actually filed.
okay. So here's what we need to do. Are you able to contact her this morning, Mr. Sonardi?
Right. I got her number on you, so.
Your Honor, if it's okay, I have, warrant in Polk County if I could.
Yes, you're free to go. So I tell you what, let's do this, Mr. Sonardi, let's just take we'll recess as far as Davion Murphy, and I'll give you a chance to, because we're going to need to set another date, because I'm going to need to actually physically take a look at what these records are, and we need to have further discussion on this, and whoever needs to be able to argue the motion. So why don't you find out her availability for the remainder of this week and Monday and Tuesday of next week, so we can get that done. Are there any other issues as to Rashad Murphy, Sean Gathright, or Isaiah Chance?
No, Karen, the only thing, and this may not be the time, but I know we were talking about deputies. They want to talk logistics as far as how we're going to plan on fitting everyone.
I was gonna bring that up, Jeff. There's a small army on the side of the fence.
That's only about half of us, I think.
Okay. Well,
You're just gonna leave that up to us and the court staff?
yes.
Do you have anything you don't want? Because
No, I really don't. As long as you guys can get to the podium without having to create a distraction, that's all I care about. So
and certainly having ingress and egress without
yeah,
the staff being concerned about.
correct. So I do think anybody that's not going to be speaking on the record, okay, staff that's not going to be speaking on the record, do you want them in the well, or are they okay in the audience, or what do you think?
Judge, in previous experience, I could tell the court that for me personally, my investigator is critical.
Okay.
In a number of different ways in a trial this big.
Okay.
So I would suggest to you that I would need my investigator at council table.
Okay. So how many people total? You have yourself, Mr. Hernandez, your investigator. Who do you need at table in addition to your client?
Mr. Hernandez, myself, and the investigator.
Okay, so you need 4 people.
Correct.
Okay, Mr. Sonardi, how many people do you need at council table?
Your Honor, obviously, myself myself. I'd like to have my investigator, but it's possible that she could sit behind me so she's not.
Okay. Could your investigator sit behind you, Mr. Gonzalez?
I'd rather not, Judge.
Okay.
I mean, unless it's a crisis situation, because he does work very closely, not only with me,
Okay.
but with Mr. Murphy.
Okay. So they want,
And I would like Scotty Sinardi, the other.
Yes.
attorneys with me.
and Mr. DeLauder.
I don't know.
Your Honor, I'm considering I'm the smallest fish in the pond and the last one on the totem pole. I'll go wherever I need to the facility. It'd be nice to be at the table,
Right.
but wherever I
Need be, we can throw you off the island into the audience, right? Okay. But 5, preferably in a perfect world. Okay, Mr. Wise?
Here we have Ms. Finkelstein, you may recall Mr. Mendez is third chair counsel as well. He's been here for some of the proceedings. And then I would like our investigator / mitigation expert, at least during jury selection, if there is a definitive phase.
Okay, so 5
Yes.
people. Okay, Mr. Petratus?
5, Your Honor.
5.
We can have at least 1 or 2 times.
Okay. Okay. Ooh, okay. Okay, very good. So we are,
Not very good at math. I think that's 19.
yeah, okay. That's fine. We'll figure it out. Maybe we need to change the setup as opposed to an L shape, because once we get the jury in here, it's going to be much more important that you all are facing the jury than me. So what I may do is have the bailiffs, we'll work on it, but maybe move the tables so they're actually facing the jury, and during jury selection, turn them so they're facing out towards the jury, something like that. Okay. So we'll make it work. We'll figure it out.
Your Honor?
Yep.
Hi, I'm Nick's nice investigator. I have Deborah, told me, she said she is available April 2nd in the afternoon at 1:30.
Okay. State.
Does that work for you?
It is for me, but I don't know, does it work for the state?
Sorry, what was that?
April 2nd at 1:30.
Could we make it 2 o'clock?
Okay for the state.
Okay.
I will say yes on behalf of
All right. So, and then, as to,
Judge, I also think just from speaking with Ms. Toomey and myself, there's one other matter that we may not be in total agreement about, the defendant's reported statement that she may want to bring to your attention. We have worked out most of it.
as to Davion Murphy.
Yes, ma'am.
Okay. That's fine. So I will hear those matters at 2 o'clock on April the 2nd. If the other defendants wish to be present for that, you're welcome to. It's up to you. Mr. Gonzalez.
Oh, nothing further, Judge, and thank you for the offer. I'm not sure we'll be attending, but
Yeah, that's fine. So for now, I'm going to tell the sheriff's office not to transport your client. But if something changes,
that's fine, Judge, yes.
okay. So do not transport Rashad Murphy on April 2nd in the afternoon. As to Mr. Gathright, Mr. Wise, does your client wish to be here for those motions?
I have a conflict, Your Honor. Mr. Gathright is fine with waiving.
Okay, that's very good. So do not transport Mr. Gathright. And as to Mr. Chance, Mr. Petratus. Okay, very good. All right,
The only one that's gonna be said is
Davion Murphy. Okay, and that is so that I can hear. I know you just gave me the motion. I know you just gave it to me. Now I can't find it. The motion with regards to the personnel files of 2 of the detectives from the Jacksonville Sheriff's Office.
And any objections from the defense, if we just of courtesy, just print out the exhibits that were provided to the state and hand deliver them to the court at some point today? The instructions that were all sent to us with this personnel file, those lawsuits and such, everything we attached to, is there any? Sure. Is there any objection for us providing that in advance to the court for review before Thursday.
No.
Okay, and it, for the record, it's the state's 7th penalty phase motion for order in limine? No, that's the,
Yeah, that was the one with,
yeah, that's the one I gave you all until, gave
April 10th.
April 10th to the defense to submit any case law. Oh, okay, so it would be, we're going to, as to Davion Murphy, the motion for, it would be part of the state's motion for order in limine regarding improper character evidence as to unrelated officer conduct. That's what we will hear Thursday, April 2nd at 2:00. Yeah, let's just go ahead and use in my regular courtroom for that since it's just one of the defendants. All right, so please let Ms. Toomey know, Mr. Sonardi, that I'm going to hear that motion in my regular courtroom. Okay. Okay. Is that it for today? Oh, and on the raw data, I need, how quickly do you think, how much time do you think you need for your experts to get that information over to the state's expert? A week? What are you asking for, state?
Judge, I think that as long as they get it to us within the week, I think that should give Mr. Harmon's experts the opportunity to be able to review it. I don't believe they have set Mr. Harmon's expert witness or deposition yet either, so I think that that's fine.
Judge, I probably should not let Mr. Hernandez go, but, and I don't, because I don't know the status of the way that train is rolling, certainly I'm going to just defer to whatever the court thinks.
All right, I'm going to say by April 8th, by the time we begin jury selection. Okay?
Judge, and just, that reminds me, I know that, Mr. Petridis listed an expert, a gang expert as well, that we attempted to take the deposition of, but that expert is Dr. Leap, had not actually finalized her opinion, and she said that she would have it finalized by the 8th, and we would be able to take her depo in a couple of days from that time frame. I just wanted to put that on the record just to make sure that she has her finalized opinion by that date.
Let her know, we scheduled it for April 9th at 5:30. And I let her know that. She responded, she's under the weather right now.
Okay.
Won't be a problem for April, but I did let her know that demo date, and she has
Yep.
sent me a pushback.
So that, what's the expert's name again?
Dr. Leap.
Leap?
LEAP.
Okay, Dr. Leap's report needs to be submitted to the state by
Wow. So I guess some motions, as we heard in the case, they just kind of like getting their whole courtroom schedule, getting these last and final motions done. I do have the hearing that she's talking about on April the 2nd, where none of the other defendants came except for thing 2, in regards to they wanted to exclude some of his statements. So they discussed that motion in limine, and I'll show that to you guys in 1 second. For those that are just coming in, welcome, welcome, welcome. I'm your girl, Sweet Pea. You have caught us. Yes, so jury selection is happening right now as we speak. They may be done for the day. Unfortunately, they don't have cameras in there for the jury selection, rightfully so. Just so everybody's aware, they're talking about maybe 2 weeks for jury selection. So we're talking about a trial not starting to like the 22nd, 24th. If it starts earlier, we'll be notified in order to be able to cover it. But right now, because it's a death penalty case, so all of them are facing a DP. So that's what y'all know. And I know somebody had asked me in the chat, like, well, do you think they're gonna get the DP? I don't think they will. I don't think they will because everybody is so young. And I think that I think the oldest person on this whole case is maybe in her early 30s. I don't think they're gonna give them a DP. I think they will get LWOP. So there's that for that part of it. But here you go with the shenanigans. I only went out for milk. Yeah, you like Zach, like the person, the dad that say he going out to get some cigarettes and never come back home. I don't know. We don't trust you, Zach. Like, I'm going to get some milk and he never come back home. You can't even let him go out for no milk and no cigarettes, no nothing. You gotta follow him all the way to the store. He'd be like, I'll be right back. I'll be right back. Lynn said, milk my ass. Definitely the cheater. Definitely a cheater. At least he's an honest cheater. Because some people be out here treating me like a side chick. Y'all know how I be feeling about being a side chick. I want to be your main chick. Yeah, I know you honest about your cheating. So I'll let you go out and play as long as you come home. What you say? We all cheat, Barbara? I know you ain't out here cheating on me, Barbara. Whenever I cut these lights on up in this studio, you need to be up in here. I will not accept cheating for you. That's right, Leah. Tell her speak for herself. Because when these lights come on, y'all right over here. Ain't no cheating. Treat me like no side chick. I know you faithful. Good. Good. I like faithful people. I tell you. Because I be catching y'all out here on these YouTube streets. Y'all think I don't see, but I be seeing. No, I'll just play. Oh, man. You was like, you always cheat when you watching wig videos and The Sims. That's right. Keep your cheating down to a bare minimum. I told y'all when we first got involved with each other and we started this relationship, that Sweet Pea don't want to be treated like a side chick. Like, no. I want to be your main chick. You treat the other channels like your side chick. Okay, so what I am going to do is I am going to play the other hearing. It's only like 15 minutes long. And then, yeah, we'll be waiting for the actual trial to start. We have everything that we need to be caught up with. Everything that's coming in, not coming in. And then we're going to go over to our verdict watch for our doctor who decided that he wanted to try to push his wife off the cliff. I think the jury deliberated yesterday for 2 hours. I want to say it was like 2 hours and 28 minutes. Don't quote me on that. I will get that for you. But they deliberated yesterday and they couldn't figure it out. So they went home and they said they're going to think about it. So let me get this up. We'll watch the remaining. Here go thing 2. He coming in. He the only person that has a motion at this point in time that they're going to be addressing. And this is the last motion that they have. So here we go, guys.
Okay, very good. Davion Murphy is present. Good afternoon. Is it Miss Toomey or Toomey?
I've been called both, but it's Toomey.
It is Toomey. Okay, because I believe I heard Mr. Sonardi, Senior, refer to you as Toomey, and I had been calling you Toomey, and so I just want to make sure I get it right.
I appreciate it.
To the extent I'll remember this entire conversation. Okay. All right. So we're here on, basically the state filed a motion for order in limine regarding improper character evidence. And I already ruled on the YouTube videos that were contained or listed in the motion. And so now we're here regarding the personnel files of detectives Griffin and McCullough from the Jacksonville Sheriff's Office. And the state did send me a copy of what the materials were. And it looks like there were claims of excessive force against these officers in unrelated cases. And so my question to you is, why is that relevant in our case?
Judge, I believe I also provided the state with basically an employee administrative investigative history for both Officer McCullough and Officer.
Yeah, I looked at that too.
Griffin. Okay, so the court has those.
Yep.
The state is going to be planning to elicit opinions from these three detectives. Detective Griffin, who is supposed to be a gang expert in 1200, McCullough, an expert in 6 block, and Detective Maynard, who is a gang expert in the gang of ATK. So how these detectives, and part of being able to offer an opinion as an expert is by gathering information and data and then formulating an opinion. The basis and manner in which these detectives gather that information and gather that data in order to formulate their opinion is derived from cold contacts, which is just approaching individuals on the street, and also traffic stops, lots of traffic stops. So in order to be able to, and Your Honor has discretion, obviously, regarding the cross-examination of witnesses. In order to be able to attack their credibility and the reliability of the data and information that they're relying upon in order to render or reach their opinion, I think it's fair game for cross-examination. I'm not intending on introducing the lawsuits themselves, but I think at least questioning them about the fact that there are these lawsuits that are pending, of which deal with Detective Trey McCullough, Daigle, who is a supervisor of the gang unit. He is the supervisor of both Detective Craig Griffin and McCullough, is my understanding. And Doug Howell is also in one of those suits. I believe it's the second suit, the 2025 suit involving Jamari Brooks. And with regards to Doug Howell, and I believe the state can correct me if I'm wrong, but he was listed at some point in the state's witness list as a witness for the state. And this Doug Howell, who was I believe still is, a detective in the gang unit. There was a big to-do about this detective in the gang unit tweeting, making biased racial tweets, and therefore the public finding out about this, basically calling for the disbandment of the gang unit in Jacksonville. It also would go to the fact that our client was essentially on the run, if you will, for about 6-7 months. Mr. Murphy was born in Jacksonville. He's very familiar with how the Jacksonville Sheriff's Office operates, how the gang unit operates, how its detectives operate. And it would be relevant to why he was hiding out from law enforcement, because he was afraid. So on those two fronts, I think it goes to the reliability and the credibility of the state's experts' opinions and the underlying reliability of their opinions, which is fair game for cross-examination, as well as relevancy as to Mr. Davion Murphy's being on the run for 6 or 7 months. The state's most likely going to argue that that's consciousness of guilt when it is the opposite of that.
Okay, just to be clear for the record, there were two, looks like there are two civil complaints filed in the Middle District of Florida, the United States Middle District of Florida, and I only see Detective McCullough listed as a defendant, correct?
He is listed as a defendant in the Jamari.
Yeah, in Brooks and both, Lakean Woods?
Lakean Woods in both.
Yes, listed in both.
And Bo Daigle is in Brooks as well as Lakean Woods, the first case.
Yeah, but you indicated, I think, in state, okay, so state, the Detective McCullough is gonna be a gang expert with us?
He is, Your Honor, and Bo Daigle is not with the gang unit any longer, he's not in the gang unit at the time. That several of these, I guess, complaints were made. I don't expect that the state would be calling Mr. Daigle in any capacity in this case, so obviously, any of the actions that were just mentioned relevant to Mr. Daigle as one of the persons as the subject of these lawsuits, the state would ask that the court dismiss. As to, would you like me to continue or you want to go?
Well, no, and so Detective Griffin, again, he's just testifying as a gang expert?
Correct.
Okay. And Daigle's not testifying at all?
No.
Okay. All right, anything further?
McCullough is testifying, Your Honor, but Detective McCullough was also not in the gang unit at the time of the text message that was just brought to the court's attention. I did cite very well-established case law, and for the record, there are no instances in this particular case where Detectives McCullough or Detective Griffin would have had direct contact with the defendant, nor any claims from the defense of excessive use of force.
Okay, so, the case law is pretty clear, and it is as follows: when the matter is wholly unrelated to the case at bar, the evidence should not be admitted. And that would be the Florida Supreme Court opinion, Breedlove versus State 580, Southern 2nd, 605, Florida, 1991. In this case, I'm not alleging, I haven't heard it, excessive force, so that's not the issue. These detectives are gonna be testifying as gang experts, so any rationale for this to be used as impeachment evidence for the jury is pretty remote in kind of nexus. So I'm gonna grant the state's motion in limine as to the personnel files of Detectives Griffin and McCullough.
Judge, if I may, just for clarification, with regards to the summary or the history of the employee administrative history for these two officers, McCullough and Griffin, there are times where McCullough had to receive remedial training as well as as well as
Right, but for unrelated stuff that's got nothing to do with this case. So even looking at these, the employee administrative investigation histories of McCullough and Griffin, there's nothing in here that has anything to do with anything that's an issue in our case. So, as indicated, I'm gonna grant the motion limit. Okay, anything further today?
Judge, there was, and I know that Ms. Toomey and I have gone a long way in reviewing the defendant's statements about retractions that we can agree upon. I think we're almost like 95% there.
Okay.
So I don't know if you want to, if they're prepared to address it now, or we did bring the transcript. It's up to Ms. Toomey.
I'm at the pleasure of the court if you want. Was there stuff you don't agree upon?
There is, Judge, and I believe that Ms. Toomey wanted some additional material taken out. Is that correct?
yeah, we went through the main objection, or the main
Judge, I did bring a clear copy for the court.
Okay.
portion of the interrogation that we would want out would be anything said or asked or stated prior to Mr. Murphy being ready to bring in the rights. I believe that ends on page 13.
State what's your response to that?
Judge, I don't believe there's any reason to take it out, and there were, in a lot of the portion while he's in the room himself, he is talking audibly out loud. He's rapping, and there are statements in there that specifically go to consciousness of guilt. I don't want to go into all the language that he uses, but he says how to hide in plain sight, and he has been on the run for months.
And is that him just talking to himself?
Yes, Judge. He's rapping out loud to himself. He's talking. It's before there. A lot of it is when he is alone in the room by himself, but the audio is
not
tiny.
interrogation, so why isn't that admissible, Steve?
Judge, I would agree that part's not interrogation.
Yeah. So as far as that goes, that being the objection, if it's true Miranda, if it's not custodial and it's not, he may have been in custody, but it's not an interrogation, he's talking to himself. So there's no Miranda problem. So, okay.
But with regards to any questions that are asked by the detectives to.
Well, like what specifically questions?
Anything. And it's really not even relevant. You want a water or anything, bud? No. You want a cigarette? What kind of water? What kind you want? It's just going back nonsense. It's really just not relevant.
Just state what's your position on that.
Judge, obviously, we do have to show that
It was
this
a
is
voluntary
voluntarily, and they are making concessions to him for bathroom breaks, whether he wants something to drink, whether or not and they do promise that after all of this, they actually do walk down the street to get him, they can't smoke it in there, but they are talking to him and trying to make accommodations for him.
Okay, yeah, that's admissible too, because that is right. The state's got to prove it's voluntary by the jury. Okay, anything else in the interview?
Did you want to address the ones that we agreed on, or?
The
No,
ones that
I don't
we agreed on.
You need to address them.
Okay.
I'm over here
Just
to
for
resolve
the record,
disputes.
there's no issues.
Just to resolve disputes. Not to babysit. Okay, well, take a look at it, just make sure, if there's any, and we can address it, we'll be picking a jury for a week and a half, so we'll have plenty of time.
It's just a few.
That's,
I just trying to make sure I have all the redactions done.
That can be
you guys get together, just make sure, and if there's any other disagreements, let me know, we'll talk about it, but it should not take too terribly long.
Okay.
So I'm gonna give this back to you, and I'm gonna give the state back a copy of the personnel files of the detectives. And I'll see you all Wednesday.
Okay, so just so everybody knows, this hearing that was done is the judge decided that his statements that he made in regards to him being on the run when he was in the interrogation room, they're all coming in. So whatever he thought he was going to get away, because he was the one that was on the run for like about 6 or 7 months. So thing two had some things going on. So he was able to, stay up under the radar. So just so y'all know, that's basically the ruling that she made on this one. So what we're going to do at this point in time, y'all do know that they are in jury selection. Unfortunately, we are not going to be able to watch the jury selection. They say jury selection probably is going to take about 2 weeks. So we will be back covering this trial from gavel to gavel coverage. Somewhere around the 22nd, 23rd or 24th, depending on when they get done with actual jury selection. Remember, it's 4 defendants, so it's going to be a pretty lengthy trial. The judge did say that they will be done by May 15th with everything. So I don't know. I hate that she giving out these when they're going to be done, because it's kind of like she already conceding what it's going to be. And she did that in the last trial with Alicia Andrews. She told the jury, "Oh, you're going to have the case by Friday by any means necessary." So if the jury doesn't get the case by that day, then they looking at the judge, they're looking at the defense like, what is going on? And why are we having this issue? So hopefully she doesn't do that again, because I think that was a real big problem for me, because it was like she already told the jury they're going to get the case and what it's going to be. So everything in between that, even if the defense asked for a direct verdict, which they did in Alicia Andrews' case, a direct verdict wasn't she denied it. So she already had her mind made up a long time ago that it was enough evidence to go to the jury. So it just seemed like she had her mind made up. So I'm hoping she can kind of defer from doing those things when we go into court for this case, to save face. And I know a lot of people were asking me about Alicia Andrews. With the Alicia Andrews case, just so you guys are aware, this Judge Cisco, she was disqualified and removed from the case. So she does have a new judge, and her new judge is currently looking over the transcripts and anything that happened in this case. And Alicia Andrews' attorneys said they want a new trial or throw this out, whatever you got to do. But this wasn't right with this trial. So, guys, I really think that she's going to be entitled to either a new trial. I don't think they're going to throw the conviction out and she get to walk away scot-free. But I definitely think that she's going to get a new trial, and rightfully so. I mean, she can be as guilty as they want her to be, but you're going to have to get her guilt the right way. And that's all I'm saying. So these people can be guilty, but we got to make sure that they go, that the state prove whatever their guilt is. And I don't even know how they got manslaughter on the table for her. But yeah, that'll definitely be going. That'll definitely probably be a new trial. So I'll keep everybody up to date on that one. If you are going over to watch the verdict watch for our doctor that decided to push his wife. Well, he tried to push his wife off the cliff. Yeah, I don't know. He wasn't successful with that. He wasn't even successful with taking himself off the cliff. He wasn't successful with anything. But anywho, he's in court in regards to what he tried to do to his wife. And the jury is currently deliberating. It will drop you guys off directly over there, so you don't have to do anything, because I have already redirected our stream. For those that just came for the update for the Foolio redrum trial, make sure that you have your notification bell on, you subscribed. That way you'll get the first alerts once we have the information regarding the trial start date. I can tell you, I did make contact with someone in the courtroom that is going to be so nice to let me know once the jury is seated. So I'll know. And as soon as I know, you guys will know, right? So that's awesome here. All right, guys. Thanks for tuning in. Thanks to all the new subscribers, mods, the chat family. And I will see you guys over there in Hawaii. I might just go put on my Hawaiian necklace, right? I got my little Hawaiian beads. I'm gonna put them on because I don't have no other reason to wear them. So now that we're in Hawaii, maybe I should wear them. All right, crew. Thanks. I'll see you out here in these YouTube streets.